On Tuesday, the Supreme Court heard arguments in a case that could change the internet as we know it. For nearly 3 decades, websites, including social media giants, have enjoyed protection from being sued, but that freedom hangs in the balance. The case, Gonzalez v. Google, was brought on by the family of American college student Nomi Gonzalez, who was killed in a 2015 ISIS attack in Paris. The Gonzalez's lawsuit against YouTube's parent company alleges Google aided ISIS because its algorithm helped the terrorist group recruit new members.
Attorneys for the tech giant argued it is protected by Section 230, which is part of a 1996 law that shields internet companies like YouTube from some liability for being sued from content posted by the users. Now, the 9 justices hearing the case wrestled with both arguments. At one point, Justice Elena Kagan actually admitted to being confused, saying, do the 9 members of the Supreme Court really know about these things being tech issues? Here to clarify what's going on in this case is my colleague at Reason Magazine, Elizabeth Nolan Brown. She's been following it, and she joins us this morning. Welcome, Elizabeth.
Hi, thanks for having me.
Yeah, thanks for joining us. So I read a lot of the transcripts and the reaction to the oral arguments that went on yesterday. It seemed to me that Google had a really good day, that the anti-Google forces did not put together a very coherent argument. The Supreme Court justices on all sides of the spectrum seemed to really not be buying what they were selling at all. But what was your reaction?
Yeah, that was definitely my reaction too, and more importantly, perhaps it was Eric Goldman's reaction. He's a First Amendment lawyer who is pretty much the #1 expert in this stuff, and he said that he came out of yesterday watching oral arguments saying that he does not think that there are 5 votes in favor of the plaintiff, and he is much more optimistic about Google winning the case now after seeing the arguments yesterday.
So can you talk to us a little bit about, what's at stake? Because getting rid of Section 230 is something that has animated some on the right, some progressives. There's actually been some kind of bipartisan hostility to it. Broadly speaking, Democrats are angry with social media companies for allowing too much content, allowing too much disinformation, want to hold them liable for the consequences of that. And Republicans say, well, if you're going to censor us all the time, if you're going to take down our content, then you don't deserve this tremendous liability protection you have. I think both sides have not really thought through the consequences of suddenly, yanking away this protection. So why don't you speak to those?
Yeah, the consequences would be just huge and myriad. Some that follow directly from the implications in this case are, anytime a video posted to YouTube or a tweet or anything on social media, a search result on Google, could be said to influence someone to do something bad, whether that be something dramatic like a terrorist attack, or whether that be, they watched videos of people eating junk food and they had an unhealthy weight, or, they or a teen who watched things about a dumb viral challenge and they did that. It would open up the floodgates of lawsuits against social media companies and internet companies in general, from people that just for things that were tangentially related. Basically saying anytime a user posts anything that could be said to have caused any harm, someone could bring a lawsuit against that. And I think it's interesting that the justices yesterday, several of them mentioned this. Kagan mentioned it, Kavanaugh mentioned it, Roberts mentioned it. So across liberal conservative lines too, you had people being like, wouldn't this, lawsuits would be nonstop, said Kavanaugh. And that was, I think, a lot of the judges seemed to get that.
Well, it didn't seem to be necessarily unanimous. Ketanji Brown Jackson asked whether, she said, quote, that seems to me to be a very narrow scope of immunity that doesn't cover whether or not you're making recommendations or promoting or doing anything else. And she said that after reading an interpretation of the statute. So one of the questions that has been raised, even by people who are defenders of Section 230, is whether or not there's a difference between saying that someone's liable for publishing the information versus saying someone's liable for promoting certain kinds of information in the way that publishers like the New York Times or any traditional news source do. Saying the distinction is promoting different kinds of content over other kinds of content and making kind of editorial decisions that are different from saying, hey, I'm just Google, I'm hosting a website, I'm not responsible for what's happening here. And isn't the argument that's being made that some of these algorithmic decisions are so sophisticated and so purposeful that they ultimately end up going beyond saying Google is a host, YouTube is a host, and saying I'm actually now putting my thumb on the scale in a way that is meaningful and potentially meaningful in a way that raises the specter of liability?
That is definitely the argument being made. I don't think it's persuasive. That was, what Google was arguing yesterday. And it did seem like at least some of the justices did not find it persuasive. They talked a lot about whether or not this is a neutral algorithm. And that's, algorithms are by definition not neutral, right? They promote certain kinds of content versus based on, how much engagement it's getting, based on how long people watch it for, things like that. But it wasn't like YouTube or Google was, directly being like, we will promote ISIS videos. It was these videos were being promoted because of an algorithm that was neutral in the sense that it was, content agnostic. And this is one of the things they talked about yesterday too, was, if someone compared it to if you go into a bookstore and you say like, hey, I would like a book about birds. And someone says, oh, the books about birds are over there. And then for some reason there was something, defamatory in the book about birds. Can't imagine what, but just go with it for this stupid example. I'm saying, you wouldn't hold the person who said, hey, the book's over there about this bird liable. And they argue that this is the same thing with algorithms. I mean, all it really does is direct people who are on the site to content that others created. It's not actually, recommending that, endorsing the content of those videos.
But isn't that the fundamental question? And I'd be curious to know exactly how much of this came out in the oral arguments. The question is whether or not the algorithm is in fact value or content neutral. The argument that's been made in the past is that it in fact directs people to more high conflict, antagonistic content, which tends to be a lot of hateful content. Many people have experienced what it's like to click on one kind of video and be very quickly funneled to the kinds of content creators, I'm going to avoid naming, names, that tend to spend time attacking other groups of people, who tend to be kind of, more divisive in their rhetoric. The tendency isn't just to funnel you toward cat videos, but quite the opposite. And so in your analogy, it might be going into a bookstore and having all of the books on the front of the store and on the front of the shelves being how to murder, how to get rid of a body, how to start a cult, how to, abuse your wife, right, and putting all of the, let's say, healthier, socially more adaptive books in the back of the room. And if that were the case, I think the question society is dealing with is whether that bookstore should, even in those circumstances, be liable.
Well, yeah, I mean, that bookstore would still be within its First Amendment rights to do that, though, which is one thing to keep in mind. Even if we would wish that the bookstore wouldn't do that, it still would be allowed to and not be breaking any laws. I think the thing also to remember is, these algorithms on social media, they're not deliberately sorting for any sort of content. They're deliberately sorting for engagement. And if people happen to be more engaged in things that are controversial or sometimes hateful or sometimes misleading, it's sorting for that. It's not necessary. So it's really us that are driving the algorithms in a way. This has been a big question in the courts, and so far courts have come down on the side that no, algorithms do not change the Section 230 equation. So just because there's algorithm recommendations, that doesn't take 230 away. Obviously, that's what this case is about. I think one other thing that's really interesting and important to bring up, though, is that Section 230 also protects internet users. That's specifically in there. It's not just the tech companies, it's the users. So if we got rid of Section 230 or if it was amended in some way, it could have bad results for social media users as well. And this was talked a little bit during oral arguments yesterday, too. Amy Coney Barrett said, I think your position is leading to the argument that retweets or likes or someone saying, check this out, the logic of your position would be that Section 230 would not protect in that situation either, correct? And they said, yes. So we see the logical conclusion of this could be something like if you retweet something and someone says that caused emotional distress or that was defamatory or that was for some reason otherwise, actionable in court, someone could be held liable for that without Section 230 as well. So it's not just tech companies that are being protected.
Yeah, it was nice to see the justices, they really did grapple with that stuff. I was surprised because I've bashed, the members of Congress before when they haul the tech executives to testify, and it's clear they don't have no idea, what a Facebook group is. But the justices, or at least they've been briefed on it pretty well because they seem to understand an algorithm. Right, they talked about tweets and retweets. They, despite Kagan's comment that what do they know, they were certainly more informed than Congress on the matter.
Yeah, that was probably the best quote from yesterday. We are not like the 9 greatest experts on the internet, is the direct quote. But, they were willing to admit that, which is at least better than Congress. They were willing to admit that and ask questions that sort of reflected at least some humility, too, which is, like you said, much different than members of Congress who tend to act like they are the greatest experts on the internet.
Well, we've got oral arguments on a very similar case coming up today, I believe, right? And that case involves Twitter, is that correct?
Yeah, this one is the same sort of case. It's someone who was a victim of a terrorist attack. Their family is suing Twitter, and also Google and Facebook were in the lower courts on this case too, saying that because they failed, even though Twitter does not allow ISIS content, but because it failed to remove all ISIS content, sometimes it slips through the cracks, that Twitter is still guilty of violating the Anti-Terrorism Act, and it's guilty of aiding and abetting ISIS. So very, very similar circumstances to the one yesterday, except this one doesn't implicate Section 230.
Yeah, very interesting. Well, we will be following that. Thank you so much for joining us, Liz.
Thank you.
And we'll have more Rising right after this.